Hi, my name is Bill Cottrell, and we're back on the air with Law Talk. As a disclaimer, we're just going to discuss law today, and no one listening to this show should rely on anything we talk about today in terms of providing legal advice. We're just discussing the law today. And with me today is Teresa Molinaro. She's a Burnsville attorney, lives in Mendota Heights, and we're going to be discussing about wills, beneficiaries, a little bit about probate and that type of thing. Thanks for coming today, Teresa.
Thanks for having me.
Tell us a little bit about what you do with respect to wills, and when people come to see you, how does that get started?
Okay, so I'd say 30% of my practice is devoted to estate planning. We also do a lot of estate litigation, so we get to see kind of when we write the wills, what are the issues that can come up in court, which is kind of a nice thing to know. But when people come in, we usually sit down, we have a consultation. It usually lasts about 30 minutes to an hour. We discuss people's estate plan. Do they have anything in place? And kind of what are their goals for estate planning, and deciding whether that can be accomplished through a will or whether they need a trust in that situation.
Do most people need wills, and if so, why?
So I always think of a will kind of as a safety net. So in some circumstances, not everybody necessarily sees the need for a will. For example, if they're single and they have kids and they want their children to inherit everything, sometimes you can accomplish that through beneficiaries and maybe some certain types of deeds on real estate. So I don't know if you've ever heard of a transfer on death deed, but it's like putting a beneficiary designation on a home. So you can transfer real property that way as long as that deed is recorded before you die. It's a way to almost akin to putting a beneficiary on a home. And then a lot of other people's accounts now have beneficiary designations. So a will, I kind of explain to people that can do estate planning that way, is kind of the safety net in case one of those things fails. For example, if a beneficiary dies before you do, or the transfer on death deed, let's say the person on there dies as well, then the will kind of comes into place to, be the safety net. Now, if you're married, a will is very important because you want to make sure that you want to leave everything to your spouse. So you want to make sure that is done correctly through a will. Or it's a good way, it's the only way to really give certain types of gifts to people or charities. That can only be done through a will. A will is also where you distribute your personal property. So knickknacks, guns, certain personal property that can only be distributed through a will.
Now, I noticed a lot of people get confused over a will and beneficiaries, and let me explain that. They'll leave something to someone in the will, or maybe they'll leave everything to someone in the will, but the beneficiary will direct that same asset to somebody else. Can you explain why it's so important that people know the difference?
Sure. So anytime that you have a beneficiary designation, that actually trumps whatever you put in your will. So if you have a beneficiary on, for example, an IRA or a 401k, after your death, that beneficiary can contact that company, and that company is going to cut them a check. I mean, there's some paperwork they're going to have to fill out, but in general, they're not even going to look at what's in the will. They're just going to pay out those people. So if in your will you have something else, then you just have to remember that any time that you have a beneficiary designation, that's going to trump whatever you put in your will, unless your will specifically references that account. And it has to be a very specific reference, so most people don't have that. So yes, that's one of the most important things that we talk about in that initial consultation, is kind of, making sure that those two things are in alignment with each other, that will and that beneficiary designation.
Now, some people remain married but are physically separated. Could a person omit their spouse from a will?
In Minnesota, you cannot disinherit a spouse completely, so that is not allowed by the law. Even if you're separated, that doesn't matter. They look at whether you were divorced or not. It doesn't matter if you're in the middle of divorce proceedings. You have to be divorced with a final judgment and decree. Now, you can disinherit a spouse if the spouse signs off on that. So sometimes you see that in second marriages where they're both coming into the marriage with their own assets and they don't want to commingle those assets. The spouse can sign a separate waiver of their rights and be disinherited under the will. But if you do try to disinherit a will, the surviving spouse has certain rights to elect against the estate. And that election, it really varies depending on how long you were married. So they might be entitled to 5% of the estate up to 50% of the estate for long-term marriages. But that's probably one of the most complex areas of probate, is figuring out what that elective share is and what can be gathered with that.
And same question for children. Say families had a situation where one of their children has decided to have nothing to do with them. Can they be omitted from a will?
Yes, children, you can disinherit children in Minnesota, and you see it quite commonly. Anytime that we're dealing in a situation like that, the only way you can do that is through the will. If you die without a will, it doesn't matter if you've told other people that you want to disinherit that child, or even put it on a writing. You cannot do that without formally executing a will saying that you want that child to be disinherited. It has to be in writing, and it has to be witnessed by two people.
Now, when I draft wills for people, they're often married, and they oftentimes set up a will where they leave everything to their spouse. And if the spouse dies first, it goes to the other spouse. And if they both were to die, then it goes to their children. But what I think a lot of people don't realize they can do very inexpensively is they can leave small gifts or small amounts of money to anybody, anyone, or to a charity. And can you tell us a little bit about that?
Sure. So kind of like I said earlier, the only way you can do that is those small gifts to charity is through a will. So how we write wills is we kind of start off by saying that certain expenses can be paid first, like obviously attorneys, right? We want to get paid. Funeral expenses, last medical and illness, those all kind of get paid off the top of the estate. And then second, we make that special gift list, where we can get rid of our personal property. That list comes into play. And then along with that, you can make specific gifts to people. So it can be I've done wills where we're leaving as little as $500 or $50 to somebody, or even specific bequests like a quilting machine. So those get made, and then what's left gets distributed to the people, to your heirs or your spouse or the other people that you want it to go to. But yes, definitely, we see it a lot with people leaving specific gifts to grandkids or great-grandkids, where they don't necessarily want those grandchildren or great-grandchildren to inherit, but they want to give them a little memento to remember them by.
I know in Minnesota there's a nice law that allows you to keep this list of personal property with your will, and you don't have to have the entire will redone if you want to change the personal property. Can you explain that a little bit?
Sure. So in Minnesota, a will has to be witnessed by two people, right? So this list is the one exception to that. So as long as it's referenced in your will, you can keep a separate written list of certain items that you want to go to certain people. And so, for example, that's kind of where we see jewelry, or like I said earlier, guns, just personal belongings. You would say, my wedding ring to my daughter, Lisa. And that list can be kept separate from the will. So a lot of times when we're doing wills, we'll pack up the will in the envelope, but we'll give them the list so they can write on that. It just needs to be signed and dated at least one time. It doesn't have to be notarized. It doesn't have to be on any specific piece of paper. And if you lose it, you can always do a new one. The most recently dated one would control. And yeah, it's a really nice way. So a lot of people think, oh, I have to put that all in their will. And so then if they change their mind, then you have to redo the will. Well, it doesn't. That's exactly why we have that list, is because a lot of times we want to change the disposition of those assets without having to redo the entire will.
Now, some people think that a copy of the will is all they need in order to open a probate file and start an estate. Can you get by with a copy? And if not, where should you keep your original?
So you can get by with a copy if that's all that you can find, but in Hennepin and in Ramsey County, for example, if you're doing a probate and you're trying to probate a copy, the judges are really going to drill you on what have you done to try to locate the original? Where have you looked? Have you checked with the attorney? You also have to file, I can't remember what the exact form is called, but it's like an affidavit of lost will, saying that we've lost the original, but this is a copy that we believe to be an accurate and true and correct copy. So yes, a copy can be used, but the courts all very much prefer the original. And so when people are asking where they can keep that, a good place is you can keep it with the county. The county does only charge I think around 30, different counties are different, but around $30 to store a copy with that. Now
The original.
The original, yep. Sorry, the original will. And that is confidential, so it's not going to be disseminated to your children while you're alive or any creditors, that they can't release that to anybody until after your death. And so that's a good place. If you don't want to do that, I recommend just somewhere where people will find it in your home, where you keep your important papers, or even a safety deposit box, because now we used to have the problem where people couldn't get access to your safety deposit box until they were appointed by the court. So you kind of had this catch-22 that, nobody could get into your safety deposit box until they were appointed, but the will was in there. So how do they get appointed? Well, now they have a carve-out in the statute that allows the bank to do a will check on safety deposit boxes. So it's an okay place to keep your will now, as long as there's somebody that knows that you have it.
So the bank would then be able to open the safety deposit box to determine if there's a will?
Right.
And hopefully the person who looks in there doesn't take anything while they're looking for the will.
Right.
What happens with respect to a contested will? Maybe you can give us an example of why somebody might contest a will, and how does that get handled by the courts?
So in a will contest, obviously, if somebody's disinherited, they can contest the will on either whether the person didn't have the capacity to make the will, so maybe they had dementia or Alzheimer's at the time they made it and they didn't know what they were doing, or there was undue influence. Let's say they were living with one of their children and that child kind of forced them to do a new will and leave them everything to the exception of other kids, or if there's fraud. So those are kind of the three grounds that we can contest a will on. It's very hard to contest a will. The burden of proof is on the person trying to contest it. So a will is presumptively valid. Those people have a very high burden of proof to do that. So it's very hard. What we typically see more often, though, is just a contest over who should be the executor. In Minnesota, we call it a personal representative, but a lot of times, anytime you're opening a probate, there's a court hearing. And so any interested party can show up to that hearing and file an objection. And it's usually against that, my brother shouldn't be the personal representative because I don't like him. And so then in most counties, the court is actually going to have to set that for a hearing date a couple months out, and so it kind of further delays the proceedings. But in most cases, we don't see a lot of will contests, but yes, they're common enough that our office maybe handles 2 or 3 or 4 at a time. So they're constantly coming through. But I always caution people, if you want to go through with this, it's going to be very expensive to contest the will, and the burden of proof is going to be on you as the contester.
If somebody were to successfully contest a will, would they be able to get their fees paid by the estate, or would they have to front the legal fees, or not front the legal fees, or would all of their legal fees have to be paid by themselves?
I can't remember what the exact statute says, but I think if you can prove that what you did was for the benefit of the estate as a whole, your attorney fees would be paid. So in most will contests, that the person contesting the will does have to upfront the fees, and so it's a long process of them paying quite a bit of money to contest the will. At the conclusion of the proceeding, they may get that money back if they can prove that that was a benefit to the whole. But there's always the argument to be made, well, what does that mean, the benefit to the whole of the estate? Does that mean just one beneficiary, or does that mean it had to benefit the estate as a whole? Typically, those cases settle somewhere, in the middle, and the attorney's fees all get paid out of the estate. But yes, the person contesting the will's attorney's fees could potentially be paid, but it would be at the end of the proceeding, and they'd have to upfront that money.
And then what about, we talked a little bit about administrative costs of the will. What about creditors who have claims? How does that work?
Sure. So when we open a probate, we get a notice of hearing from the court back that we have, as the attorneys, have to publish in a newspaper. And so it has to be published for 2 consecutive weeks. And then after that initial date of publication, creditors have, I believe it's 4 months to file a claim in the probate court. So I get a lot of questions. Well, do creditors really file? And yes, they do. I think they must have somebody out there that just monitors these these publications and files a claim, I mean, I've seen them for as little as $200 or $300. So yes, they will file a claim in the probate court. Now, if they don't do that within that 4 months, their claim is barred and they won't be paid, with the exception of medical assistance. So anytime you have a medical assistance claim, they're not held to the same 4 months that regular creditors are.
Can medical assistance get a lien on the decedent's, the person who died's house?
Yes.
And can you explain generally how that would work?
So usually once the person, so after they die, we're required to give notice to the Commissioner of Human Services of the death. And we basically send that same notice to creditors that we publish in the newspaper to them. And then they either send us a little 1-page, 2-page paperback saying that this person did not receive medical assistance and you're fine, or they'll usually will file a lien on the property, because in that notice we have to tell them where the property is. So they'll file that lien, and then we have to determine whether it's valid or not. I mean, sometimes there's nothing we can do about it. That is a valid lien, and that'll get paid off from the proceeds of the sale of the home. But if there's a disabled child living there or some other exceptions, sometimes we can disallow that claim. For example, I have had a probate where there was a disabled child. She wasn't even living in the property, but it was a disabled child of the decedent, and we were able to disallow that MA claim.
Gotcha.
But I have other ones where if everybody is not disabled and it's just a general probate, we do have to pay off that lien. And so that usually gets filed, obviously, after the death of the decedent.
Related to medical assistance is a lot of families, as their parents age, they'd like to be able to apply for medical assistance, but the elderly person still has considerable amount of money, so the person's not eligible for medical assistance. Can that money be transferred to relatives in order to have someone qualify for medical assistance?
We, in our office, doesn't really do a lot of medical assistance, but from what my understanding of it is if there's a 5-year look-back period. So once that person enters a nursing home and starts receiving medical assistance, or I guess they don't necessarily have to enter a nursing home, but receiving medical assistance, the county's going to look back 5 years to see if they transferred anything for less than fair market value. And if so, they get penalized or aren't eligible for medical assistance. So you can transfer property to relatives or even homes, but it has to be over 5 years ago. And I very rarely, I don't like to do that, because I tell people, you know, if you're going into a nursing home and you need that money to stay in somewhere nicer, you know, I want to make sure that that's there for you. So, and we have to be really careful when people are coming in that aren't having the capacity. You know, it's a family member saying, oh, we want to save the home for mom and dad, you know, mom and dad's house, but mom and dad can't really articulate that to me, then that's a huge red flag that mom and dad aren't really after it, it's the kids.
And what about trusts? I know there's a lot of different kinds of trusts. Let's start out with mom and dad want to set up something in case they were to die with young children. How would you protect the children in that horrible situation?
Well, usually, even in a will, we can do trusts. So there's 2 different kinds of trusts. There's revocable trust. That's something that you're setting up now and funding now. So it's almost like, you can think about it, it's almost like you're setting up a business. You're setting up a business, your trust actually owns the home, right? And so that's the revocable trust. A testamentary trust is one that we write into a will. So I kind of explain those as almost like a contingent trust. So for example, let's say I have a minor child. In my will, I say, okay, if I die and my husband is also dead and my minor child was going to inherit my money, I don't want her or him to get it until they're 25 or 30 or 35 or whatever age that I choose. And so if I do in fact die and my husband was also dead and my child was going to inherit that money, and let's say they were 40, well, they're going to get it, right? There's no trust there. But if they were, let's say 15, then somebody, whoever I named in my will to be the trustee, would establish a trust fund for them. Not a trust fund as we think of in wealthy people, but just a kind of a trust account that money can only be used for their health, education, support, and maintenance until they're that age, whatever that age is. Let's say I pick 25, and then at 25 it would terminate and they'd get whatever's left. So that's a trust that I can actually put in a will. And we commonly do we do that in almost all of our wills, because we don't think of it just in terms of kids. We also think of it in terms of grandchildren too. So anytime there's the possibility of a minor inheriting money, we put that trust language in a will. So that doesn't have to be accomplished through a trust in the sense of what most people think of a trust. Now, when we're actually setting up a revocable trust, we do that same thing in the trust, but a trust is actually, it's its own legal entity. It's a pass-through entity for tax purposes, but it is its own legal entity. And so when I die, my trust doesn't die. So the difference between the will and the trust is the trust doesn't have to go through probate, whereas a will does. And so that's a common misconception people have, is that if I have a will, it's going to avoid probate. That's not true. The only 100% way to avoid probate is to do a trust. And so I'm not sure if I think I answered your question, but
I think you did.
Okay.
One thing I wanted to make sure the listeners understand is that they sometimes believe they can set up a trust to avoid paying their debts.
Okay.
And that's just not the case, is it?
No, your creditor is entitled to, the trust assets too. I mean, they're a little harder to get to because we're not, for example, when I was talking about the probate, we're publishing that notice in the paper. And so we're kind of broadcasting to all your creditors that you've passed away and that they are free to go file a claim in the probate court, right? With a trust, we're not publishing anything in the paper, so the creditors aren't necessarily aware that you've passed away. However, creditors, if you don't open a probate, I think they have about a year to file a claim, so they can still go after those trust assets. It's just a little harder for them to find them. So, we don't always see that happen. I guess the creditors would then threaten to open a probate to try to get those trust assets.
And then the other point I wanted to emphasize is that just because you create a trust doesn't necessarily get the assets into the trust. You still have to draft a deed transferring, as you pointed out, it's like a new business or a new legal entity. The asset that you're moving into the trust has to actually go into that trust, right?
Correct. So the big asset most people have is a house, and so yes, we have to do some kind of deed from yourself to yourself as trustee, and so that is what transfer, and it has to be recorded with the county. So we actually have to do that separate deed. That's not part of the trust agreement itself. And then with other assets, we usually change the beneficiary. So, for example, a 401k or an IRA, we wouldn't change the owner of that to the trust, because that would probably trigger some pretty big tax consequences to do that, but we would actually change the beneficiary on those to your trust potentially. But yes, with any kind of real estate, we have to make sure that we transfer that asset into the trust, and so that's kind of one step some people forget to do.
Now, what about the tax man? The tax man cometh, and does the fact that somebody dies, does that change anything with respect to the taxes that they have to pay?
No. So we get a lot of calls. People ask, is there inheritance tax? If I inherit money, do I have to pay tax on it? And the answer is no. You don't have to pay inheritance tax. Now, if you're inheriting an account that wasn't taxed by before the decedent died, like a IRA or something, a Roth IRA, then yes, you might have to pay taxes when you cash that out, but you're not going to owe the state any inheritance tax. And the decedent will only pay estate tax if their estate is over $1.8 million. And so
is that state or federal?
That's state. So the state level is 1.8. It's going to go up to 2 million in 2018, I think. So we're kind of planning, when we're doing these wills, we're planning for $2 million. In the IRS level is 5 million, and so I don't see a lot of clients that are too worried about the IRS level, but it does include life insurance payouts, so we do typically get worried about the Minnesota one in quite a few of the people's estates. And so, but let's say you weren't worried about 2 million. Let's say your estate's pretty modest. It's 500,000 or something. Then the only taxes you might owe would be, you still have to file, so your personal representative still has to file your last 1040 for the year. So if you die in July, you have to file a return for that period from July, and then your estate actually has to file an estate return. Now that's different from the estate tax of that 2 million, but it's just if your estate earns income of over $600. So let's say, for example, in one of my probates we had, the estate owed or owned stocks, and they held on to them for about a year or two. And so those stocks had appreciated by the time that we got around to selling them. So there was a small gain that we had to report and pay some taxes on. But typically the taxes aren't very high. You do get a step up in basis in most assets to the date of death. So then you're not talking about a basis that the person who owned them had. You're talking about if the stocks were worth $50,000 on the date that somebody died and you turn around and sell them 2 weeks later, you're probably not going to have a huge gain or loss there. You're not going to be getting the same basis that if they paid $10 for that stock, for example. That doesn't matter.
Now, I had a question for you. Personal representatives, typically, do they get paid for their work or do they not get paid? And how does that get determined?
Okay. In Minnesota, personal representatives are allowed to be paid a reasonable compensation. So we don't have any bright line rules about what they can or cannot be paid, but they can be paid. And so it's typically $25 to $35 per hour. More if they're doing, if it's a lawyer, they might get paid more if they're doing the legal work. I just tell people when they come in to hire me, say, okay, keep track of all of your time. Even if you're not planning to get paid right now, you might not realize how much work this is going to be, so you want to keep track of it, and at the end of it, you can decide whether you want to be paid or not. Now, you will have to report, they do have to report that on their tax return as income, so sometimes that deters people from getting paid.
When you're writing a will, do you ask the people if they want the personal representative to get paid or not, and then do you put that into the will?
I usually do not. We discuss it, but most people, it's hard because I've probated a couple wills where the personal representative has been paid a fixed amount. And sometimes that fixed amount is very little, if it's a contested case. $5,000 might seem like too much or too little, depending. You just don't really know if it's going to be a really easy case or if it's going to be a really difficult case. So it's hard to assign just a straight dollar amount because you really don't know if that's going to be a lot or too little. So, and I think most people are comfortable knowing that the personal representative will get paid a reasonable compensation.
Well, we've only got a couple minutes left, and I know we really haven't, we just sort of touched the surface of this interesting subject. Is there any advice you can give the listeners about what they should do if they have questions about a will or about estate planning, that type of thing?
I would say call an attorney. Most of us offer free consultations. We'll talk to you on the phone or even in person. Find one that you get along with and you trust, because that's really important. But also remember that a will is only really one piece of it. You also have to think about a healthcare directive and a power of attorney. So those are really three really important documents. And with a healthcare directive and power of attorney, you can actually get those online for free if you wanted. So I would definitely recommend doing that. Now for a will, I don't recommend doing it online. We've seen too many of those situations go wrong, and every time that I sit down and talk with people, there's things that they're learning that they didn't know that if they had done it online, it wouldn't have been addressed. So call an attorney just to get some advice. Some community ed programs offer writing your own will courses, so check those out as well.
And I think if you were to try and write your own will, you'd still want an attorney to review it, because you wouldn't want to be worrying the rest of your life whether you made some horrible mistake that only your heirs will find out about after you die.
Right.
Well, Teresa Molinaro, I'm sorry.
That's it.
It's so nice to have met you today, and thanks for joining us on this show, and hopefully we can have you back for other questions that arise with related to probate and trust and that type of thing.
Sounds good. Thank you for having me.
Yep, thank you.
Yep.